Thank you.
This will be here. Mr. President, other distinguished panelists, and all my friends. First of all, I thank Bar Association of India for giving me this opportunity of participating in this program. And I feel it is a great privilege to participate in this function, which is presided over by the President of the Bar Association, by Asian Bar Association, Sri Sham Diwan. Now coming to the subject, BNSS. Let me start with the title of the enactment. It says Bharatiya Nagarik Suraksha Sanhita. Now actually, as I find, 90% of the provisions here are exactly what were there in the Criminal Procedure Code 1973. There are few changes effected, some deletions, some additions. Barring that, I don't find any major change in the procedure either from the code or otherwise. And you can't say it is a very old code, colonial legacy. In fact, the Criminal Procedure Code 1973 was enacted 25 years after independence, and after there were at least 4 reports of the Law Commission of India and some experts committees. Then this 1973 Act was enacted. Now the very preamble says it is an act to consolidate and amend the law relating to criminal procedure. But the title is nothing to do with the criminal or procedure. It says, if my knowledge of Hindi is not limited, it virtually means Indian Citizens Protection Code. In fact, the entire code, there is no protection of the citizens is involved. It is a criminal procedure code. So I don't know what is the need for having this. Merely by saying it is protection of the citizens, you don't get any protection. The only change I find is the title is in Hindi, and we from South find it rather difficult to understand. I am not against Hindi. In fact, I am a great lover of Hindi. I studied Hindi from third standard up to graduation, and I passed Hindi in second class. But what I am saying is these changes were wholly unnecessary. Secondly, the changes which have been effected could have been easily done by amending the 73 code. It was wholly unnecessary to have changed all the sections from one to the other, because whether it is the judges or lawyers or the police, you are all very familiar with the various provisions. A private complaint, 200, FIR 154, all these sections, you know it well. Now, these are all changed. The point is, it will take another 25 years for even the experienced lawyers and police to know which is the corresponding provision which is there now. So this change is not in the interest of the criminal justice system. The object of speedy trial is not achieved by this. On the other hand, it places obstacles in the way of criminal justice system. Now you see, now supposing it is supposed to come into force on 1/7/1924. Immediately thereafter, whatever crime is reported to the station house officer will not be knowing which is the relevant section. He has to go to the table and see which is the corresponding provision and all that. All this was unnecessary. According to me, not more than 10% of changes have been effected. These could have been done by an amendment act so that the relevant provisions will be same. Wherever there is change, we can could have adopted the changes. Now, first coming to the question of FIR. Now, 154 was the section. Now it has become 173 in the Sanhita, new code. Now, as you all know, there was some difference of opinion as to whether when information of a cognizable offence is given to the station's officer, is he bound to register the case immediately, or could he hold some sort of a preliminary inquiry before registering it? This question was settled by the Supreme Court in the case of Lalita Kumari, in which they said that the SHO has no discretion. He should immediately register the FIR, and there is no question of any preliminary inquiry, except they spelt out a few contingencies where it's a dispute, matrimonial dispute, or Prevention of Corruption Act, where the information is about disproportionate asset, a preliminary inquiry could be held. And even that preliminary inquiry, Supreme Court made it very clear not to find out the veracity of the information, but only to find out if it discloses a cognizable offence. If it discloses, you are bound to do it. Now, a major change has been effected under the new Sanhita. It says if the punishment for the offence is between 3 years and 7 years, then SHO is given full power to decide whether to hold a preliminary inquiry or not. Only condition is he must get the approval of a rank of a officer of a rank of DSP, that's all. And this discretion is given. I fail to understand the requirement of such a preliminary inquiry. According to me, this discretion vested in the SHO to hold a preliminary inquiry or not to hold a preliminary inquiry will not only delay the whole process, but it will also give scope for more of corruption, even at that stage. It is our common knowledge that one of the reasons for corruption is where there is a discretion in an officer, there is scope for corruption. But if the discretion is reduced, then scope for corruption is less. Here, every offence between 3 and 5 years, 7 years imprisonment, the SHO is given the discretion. The result is there will be approached by both the sides with regard to the result of the preliminary inquiry to be held or not. Therefore, according to me, this is a retrograde step to overcome the ratio in Lalita Kumari's case. This was wholly unnecessary. Another important aspect I fail to understand, what is this 3 years to 7 years? If they could have said below 7 years any punishment, you can. Now there are large number of cognizable offences where the punishment is 2 years or 1 year. In those cases, no preliminary inquiry discretion is given. I don't understand the rationale for having this limit of 3 years. Therefore, according to me, this provision regarding preliminary inquiry has given scope for unnecessary delay. At least for 14 days, there will be delay in registering a case and discretion to the SHO to decide whether there is a prima facie case or not. Then it says information orally or in writing was the earlier provision. Now they say orally or electronic communication. I don't find any need for electronic communication. If it is electronic communication, then the person who has sent the information should come to the station and put his signature on the statement within 3 days. Then only it will be registered. According to me, one welcome change that they have made is the information to any police station, you are bound to register a FIR. It need not be the station which has got jurisdiction in the matter. And this was the law all through. Even when I was a prosecutor in Bangalore in the year 1962-63 itself, the session judge wrote strictures on the police who refused to register a case saying that this is outside my jurisdiction. Then he comes and asks, where exactly is the offence? If it is on that side of the road or this side. If it is on that side, you go to that station. They said, you can't say that. Now it has been clarified. But it is only a clarification, nothing new about it. So, when you have a right to go and give information to the nearest station, according to me, this provision for electronic communication was wholly unnecessary and it will again delay the matter. And no object is served by having this electronic communication because you register it only after, within 3 days if he comes. Now we are all aware of this hoax calls, threatening bomb and all such things. Now, a first information regarding a cognizable offence must be by a responsible person about the authenticity of the information. So this provision regarding electronic communication was, according to me, wholly unnecessary. It should be either oral or in writing, and immediately his signature must be taken and a copy has to be given to the informant. That is the requirement of law. Then next is about the remand, police remand. As we know, remand is one to the custody of the police, the other is judicial remand. Now the provision is that the remand to the police could be only up to a period of 15 days. That 15 days is retained. But under the old code, that period of 15 days is immediately after the arrest and not beyond that. Within 15 days itself it should be done. But now they have amended to say that it could be during the duration of the investigation, which could go on for 60 days or 90 days they say, and in some cases which is not recognized here, it goes up to even 180 days, NDPS Act, etc. So till then, there is a scope for the police to seek a remand intermittently, but the total should be 15 days. Of course, some are of the view that this 15 days is enhanced to 60 days or 90 days. It is not so. The total remand to the police could be only total of 15 days, but it could be at any time till the investigation is over. This, according to me, is a retrograde step. The earlier position was better. This doesn't help. In substance, what I say is the present code, if you analyze, it gives more power to the police than protection to the citizens or the accused. That is the point. Then another important aspect is about further investigation after the filing of the charge sheet. Now, under the 1973 code, section 173(8) provided for such further investigation. Now, earlier there was no such provision. It was introduced in the 73 Act, because if after the filing of the charge sheet, the police or the investigating agency finds some crucial clinching evidence, it should be able to gather it and file it before the court. Therefore, this provision is made that you can have further investigation and file a supplementary report to help to strengthen the prosecution case. This provision is made. But in our practical experience, we have found that this provision is being used, mostly misused by the police for various reasons. In fact, in the case of Selvi Jayalalitha herself, at the stage when 313 statement of the accused was being recorded, after the prosecution evidence was closed with the 259 prosecution witnesses, suddenly she came to power again and became the chief minister. Immediately the DBSC, that is the local police of Tamil Nadu, who are the investigating agency, immediately they said, we want to further investigate because there is a direction from the chief secretary that there has been a lot of miscalculation and therefore we want to. And as prosecutor, I said you can't do it at this stage. 313 statement is being recorded. Now there is no question. And the whole object was to help the accused to have a recalculation and say that in view of the further evidence she should be. Then, even though I refuse to seek time on that ground, the IO directly writes to the special judge, give us 6 weeks, we are going to further investigate and file a charge sheet. Ultimately, the High Court had to quash this further investigation held because it is patently it has been done to help the accused. So this way it is being misused. Only 2 years back in Bangalore, I had a case where a charge sheet for murder case is filed against 6 persons as the assailants. And long thereafter, a further supplementary charge sheet is filed with the further investigation saying that it is not these 6 accused but another 8 accused. They are added, 14 accused. Thereafter, after 2 years, another supplementary charge sheet is filed saying that one prominent politician, MLA, he has abetted it, therefore he is added as an accused. And this is done after 55 prosecution witnesses had been examined. This is how this provision for further investigation is misused. Now still that provision is retained, it's all right. But my point is, one important change made here is that if the trial has commenced, then you can't do further investigation without the permission of the court. This is a welcome change which is brought about, but according to me, it doesn't go far enough. In fact, the provision could have been made. Yeah. Yeah. Then, only one very important point I will touch upon regarding private complaints. According to me, the present provision of private complaint is virtually rendered nugatory. As we all know, Section 200 is the provision under the code for a private complaint. Now it is Section 223. It says a magistrate having jurisdiction while taking cognizance of the offence on complaint shall examine on both the complainant and the witnesses present, and usual procedure. Then it says, this is a new provision added, one provision. Provided that no cognizance of an offence shall be taken by a magistrate without giving the accused an opportunity of being heard. As we all know, from 200, 202, 203, 204, the court will, the magistrate will consider the statement and then either he will proceed or dismiss the complaint. At that stage, accused is not there. Even under the present code, 223 to 227, accused is not there. So how can the very first is a magistrate having jurisdiction while taking cognizance of the offence should examine the complainant on oath and his witnesses. But then the provision says he shall not take cognizance unless without giving an opportunity to the accused of being heard. Accused is not there. How can you give opportunity to an accused? And if you to say this provision gives the power to the magistrate to summon the accused, it will be absurd. Even without knowing what the complainant's case is, without recording his statement, where is the question of calling upon the accused to have his say in the matter? So this is total non-application of mind. And worst still is, according to me, even if you feel that one opportunity should be given to the accused to have his say in the matter, it should be at the later stage of 227. Instead of that, in the beginning itself, before taking cognizance, you give the accused an opportunity of being heard, is something that is totally not acceptable, not practicable. I have explained it in detail in my note. This clearly shows non-application of mind. So just to conclude, what I respectfully submit is that even now it is not too late in the day. The present enactment changes have been effected without due deliberation and examination and total non-application of mind, as I pointed out. Therefore, it is better that the implementation of this enactment is postponed so that all will be familiar with the new provisions which they bring about. And I submit that whatever changes have been made between the code and the Sanhita, they could be done by amending the 73 code itself, retaining the very sections instead of complicating matters by having different sections is what I feel is the requirement. Thank you very much.